I'm under federal investigation for making a joke on Twitter. In June 2019, employees at Vox Media walked off the job demanding a new collective bargaining agreement. As publisher of the conservative website The Federalist and an FDRLST Media employee, I found it ironic that a liberal-leaning publication was struggling to negotiate with its employees' union. I tweeted out, FYI at Federalist, first one of you tries to unionize, I swear I'll send you back to the salt mine. Federalist employees were amused. They joked about selling branded salt shakers and writing sympathetic vignettes about union rebels from the Federalist salt mines. Then things took an unfunny turn. The National Labor Relations Board informed me a random person on Twitter, someone who's never been a Federalist Media employee, filed a formal complaint about my tweet, claiming my Twitter joke constituted an unfair labor practice. Yes, that's right. A stranger to my organization claimed to be an aggrieved person under the National Labor Relations Act because he, unlike the Federalist's actual employees, did not find my joke amusing. He alleged I had violated Section 8A1 of the NLRA, which says it is an unfair labor practice for an employer to interfere with, restrain, or coerce employees in the exercise of their rights to organize or join unions or collectively bargain. No Federalist employee had ever expressed a desire to unionize, of course, and even if anyone had, my joke wouldn't have stood in the way. The accusation was laughable. After all, humor and satire are fully protected under the First Amendment and do not violate the National Labor Relations Act. Certainly, a satirical tweet can hardly be confused with a verbal threat. The NLRB proceeded to invade our publication, heedless of the freedom of the press. Members of my staff were subpoenaed to testify in New York, a jurisdiction where the Federalist had no office and no employees lived or worked. The NLRB attempted to subpoena all emails and communications between staff members going back for years, including editorial decisions, hiring decisions, confidential sources, all of it. Help arrived in the form of the new Civil Liberties Alliance, a nonpartisan nonprofit founded by legal scholar Philip Hamburger to defend constitutional rights against abuse of power by government agencies, also known as the administrative state. The NLRB proposed a settlement. I delete the joke. I post information on the rights of employees to unionize. The complaint just goes away. I said no. That meant the NLRB's case against me would be adjudicated by the administrative law judge in New York, who the NLRB itself hired to preside over the case. As expected, we lost. The board called no witnesses. It submitted my tweet and printouts of various Federalist articles and asserted we were not, in fact, a publication, but an anti-union website. Federalist employees filed affidavits stating they viewed my tweet as a joke, but the NLRB's in-house judge dismissed their opinions as subjective and irrelevant. The case is now in the U.S. Court of Appeals for the Third Circuit, with overwhelming amicus support over the free speech concerns the case raises. It is my good fortune to know many brilliant lawyers and liberty-minded organizations who are willing to stand up against abuses of the administrative state. Most people aren't so lucky. So why bother when the stakes seem so low? Because they aren't. The NLRB erroneously interpreted its own governing statute to mean anyone can press unsubstantiated charges to silence a company's opposing beliefs. NLRB has no authority to prosecute particular viewpoints and label them as a violation of the law. Individuals have the right to speak freely and satirically, to express their opinions under the First Amendment of the U.S. Constitution. And yes, even government agencies have to abide by that. It's a matter of principle. What happens when another small business owner on social media makes a similar joke? When a neighbor decides to make a federal case out of an impolitic Facebook post? What happens if freedom of speech is only worth what the common business owner is willing to pay in legal fees, days of missed work, and the cost of flying employees to other states to testify in front of humorless bureaucrats? It's understandable that those who can't afford to fight often bend the knee. But in that America, the bureaucrats and the trolls who weaponize them to silence speech they don't like will keep on rolling until someone stands up and says no. In this case, that someone is me, Ben Domenech.